Welcome and thank you for joining me for another episode of Tax Break. This is a podcast about South African tax for South African tax professionals and practitioners. My name is Pieter van der Schwan, and in each episode I share my thoughts with you on a topic or a recent development in South African tax. And I try to keep the episode short enough that you can listen to it while driving to work, while having a cup of coffee, or even when you exercise if you like to listen to tax while you train. Our topic for today relates to objections. So I've received quite a few requests from listeners to record an episode about, one of the listeners put it quite well, the tips and the tricks to doing a tax objection. Now, unfortunately, I think, although it sounds very nice to say that there are some tips and tricks, it's a process that's governed by the legislation and by the rules promulgated under Section 103 of the Tax Administration Act. And if you follow the process and you formulate proper merits, I don't think there's many tips and tricks involved. So what I've decided to do, instead of trying to create the perception that there's tips and tricks, is maybe just to share a few pointers on what you would find in this process and that you need to maybe just be aware of again or look out for as you go through the process. What I've also done is I'm going to break the episode into two parts. So we were looking at the process today, and then the second episode that will be published next week will look at how to formulate the grounds of objection. So what you can do, can't do, what you can do later on in the process, that kind of thing. So if we look at the legislation where an objection fits into the dispute process, the process of objection is primarily governed by Section 104 of the Tax Administration Act. And it basically says that if a taxpayer is aggrieved by an assessment or a decision, then the taxpayer should object to that assessment or decision. So if we look at Section 104, to a large extent it talks about, it deals with the timing as to when you need to submit this objection. And then there are also some requirements relating to the process, but some of these requirements we find in the rules for tax dispute resolution that were published under Section 103 of the Tax Administration Act. So I think before we can talk about doing a sensible objection, it's perhaps necessary to go back to the step in the process before an objection. So in order to be able to formulate proper grounds of objection, you need to understand why the assessment or the decision was made. So in the dispute resolution rules, there's a specific rule that deals with requesting reasons, and you've got 30 days, now that's business days, after the assessment has been issued, to request reasons for the decision. So I think a lot of people somehow skip this process of requesting reasons, and where it would become could become a problem later on is if you've started formulating your grounds of objection without fully understanding why the assessment was raised in the first place. There's also, it seems, a perception that if you request reasons, your period to object, if you haven't received the reasons by the time that you need to object, that you not requested the reasons, that you'll miss your date for objection. But if you look at the rules carefully, that's not the case. So your time or the period that you've got to object starts running once you receive your response to the reasons. Right, so if you've requested reasons and you now understand why the assessment had been issued, then you can object. Now, as far as the time frame that you've got to lodge an objection goes, there were a few changes about a year and a half or so, nearly 2 years ago, when new rules were issued under Section 103. And the new rules provide for a standard period of 80 days. So in other words, again, 80 business days from the date of the assessment to lodge an objection. And if you requested reasons, the 80 days would start running once you've received a response to that request. So in this 80-day period, it was extended from 30 business days. So what that does give you is the opportunity to make sure that you've got enough time to formulate properly thought through grounds of objection. Now, I'll talk about the grounds of objection in the next episode a bit more, so I'm not going to stand still on that. The next pointer, if I can call it that, about the process is if you were to miss the 80-day period, or you see that you're not going to be able to formulate your objection within the 80-day period, you can ask for an extension. Ideal would be to ask for the extension up front, but I've often seen instances where that was not done, and you would then have to request condonation. There's an interpretation note on the factors that SARS would take into account, being mainly the reason why you need the extension, how long the delay it has been, and also the merits of the case. Now, there were some changes at the end of 2024 in the Tax Administration Laws Amendment Bill to the provisions of Section 104 dealing with these time periods if you go past the 80-day period. I believe that it hasn't really changed what the requirements are. So you still have a period of 30 days more if you've got reasonable grounds that you can request an extension. You can go longer than 30 days if there's extraordinary circumstances, but the process can never go longer than 3 years. So the reason that for the amendments was really to clarify a perception that existed, that you had to read the prescribed periods in the context of only some provisions of Section 104. So I don't believe it's really changed the essence of these extension provisions. Right, and then so hopefully you do submit your objection in time. We've got Rule 7 of the dispute resolution rules that deal with how you should be doing the objection. So it talks about doing the objection in the prescribed form. It talks about formulating grounds, and we'll talk about this a bit more now, about providing an address where you would take receipt of the decision, the need to sign the objection, and then the period within which it must be submitted. If you comply with the requirements of Rule 7.2, then you've submitted a valid objection. Then SARS can consider the merits of your objection and allow or disallow the objection. If, on the other hand, you submit an objection that does not comply with the requirements of Rule 7.2, then you don't have a valid objection, and SARS may reject it to say it's not valid. The difference between rejecting an objection on the basis that it's not valid and disallowing an objection on the basis of merit is that if the objection is not valid, you don't have the next step of being able to appeal against that decision. There's a specific process in the rules that cater for the scenario if you believe that SARS made an error in rejecting your objection on the basis of validity. If, on the other hand, you submit a valid objection that's then disallowed, you go to the next step in the dispute process, which is then appeal. Right, there's a few things in Rule 7.2 that I would just like to highlight, especially Rule 7.2b, which talks about your grounds of objection. So the first element there is that you need to clearly identify what part or amounts of the assessment are being disputed. So we'll talk about that in the next episode. There were a few cases last year that specifically dealt with that, and I think that there's a bit to be learned from. The next requirement is that you need to identify the grounds of assessment that's being disputed. So which of the grounds of assessment are you disputing? Again, I think that it's important to understand the reasons why the assessment was issued. So going back to that previous step that I referred to about requesting reasons and fully understanding why the assessment was issued. And then the last step is you must submit any substantiating documents that's required for your objection or for the grounds of objection. Now, in this regard, I came across a recent case. It's a tax court case. The case name is Dr. X. You can go and look at it. It's a good case to read for any tax practitioners dealing with having to submit objections to SARS and providing information to SARS as part of the objection. And if you look at the judgment in that case, what the court said is that if you look at an objection, when you formulate your grounds of objection and you object to an assessment, there must be sufficient detail. You must do it in sufficient detail. It cannot be vague and general or globular statements as the judgment talks about. So it must be specific and precise. So what the court said there in paragraph 92 of the judgment, and I'm going to just read this short extract to you. I think it does give a bit of guidance as to what the proper objection should look like. An objection which is valid as a consequence of meeting the specificity requirements of Rule 72B can be rationally determined on its substantive merits. An objection which is vague, imprecise, lacks detail, and does not submit the documents required to substantiate the grounds of objection which it advances cannot. So the question in this case was the taxpayer, the SARS didn't get all the documentation or all the information that they wanted. And on that basis, they rejected the objection as invalid, whereas the taxpayer argued, but it shouldn't be invalid, it should be disallowed. And the distinction, as I've already mentioned, is that if it's disallowed, you can go into the next step of appeal in the dispute process. If it's invalid, you've got a different process to follow. So the second part of this episode that I'll record next week will then be about, in a bit more detail, about what these grounds, how do you formulate the grounds, or a few pointers on formulating the grounds. I guess while we are talking about grounds, it does make sense to say that the grounds, when you start getting to the merit of your case, the grounds would obviously depend on your specific facts and circumstances of the dispute that you are looking at. And that differs from case to case. The last comment for today that I would like to leave with you is something that is in the pipeline. The Tax Administration Act has been amended for that, and that's for ADR to be introduced at the objection stage, not at the appeal stage, or not only at the appeal stage. And the idea then is to have an ADR to basically a facilitated dispute resolution process to see if the dispute can be resolved at an earlier point than only at the appeal. There are some people who believe that this is a good development, but there are also some people who are a bit more skeptical about it. I think, nevertheless, it's something that is worth keeping an eye out for these rules as they are published. So at the moment, the rules do not yet cater for ADR at the objection, but the legislation has made that a possibility in future. Right, so to close, in summary, I think when we talk about the objection process, there's no real tips and tricks. It's a process that's governed by rules and legislation, and it's absolutely critical to know these rules and follow them. Otherwise, you are likely to run into problems. There are some periods that you need to stick to, and there's been a few changes in the last year or two. If you want to be, if you are to be able to formulate proper grounds of objection, you need to understand why the assessment was issued. So remember that there is a process to request reasons to understand that. And then, as I've alluded to towards the end of the episode, you must attach the documents that are required to substantiate your grounds of objection for the objection to be valid. That's all for today. If you've got any feedback or comments, I'd love to hear it. My email address is in the show notes. And if you've got suggestions for future episodes, like the listener who suggested this episode, please send me that suggestion as well. It's always good to see that people are listening to the show and sharing their ideas for future episodes. If you like the podcast, please like it or subscribe it on the platform that you are listening to. And also, please tell your friends about the podcast. Then just lastly, as always, the podcast is not intended to be tax advice or a substitute for fact-specific tax advice. Until next time, goodbye.